Do you want to know what your car accident case is worth here in Virginia? Watch this video and learn what we think. Hey folks, James Abrenio coming to you from Abrenio Law, your Northern Virginia personal injury and criminal defense law firm. In this video, I want to talk about a question that people constantly ask me, whether it's clients or potential clients, or individuals that have family or friends that are involved in car accident cases. James, what do you think the case is worth? What do you think we're going to get at the end of the day? And my answer is pretty simple. It's really, what would a jury do? That often asked question, what do I think a jury would do if they heard a case like yours? If they didn't know who you were, never met you before, they weren't your friends and family, they were essentially random strangers. In Virginia, it's going to be 7 random strangers that qualify for jury duty, pulled off from the street from your local community, that hear your case for maybe 2 or 3 days. Remember, they don't want to be there, and then they're asked by the attorneys to evaluate your case. That's what I'm going to say your case is worth. Well, James, that doesn't answer my question. You're the expert. I don't know what a jury would do. Give me a better answer. Isn't it true that there's some algorithm? Isn't it 3 times the medical bills? I Googled the other day, and they gave me a great formula that will help me answer the question. Well, ladies and gentlemen, what I've got to say about that, because I get that question as well, and that type of framing, and my answer to that is, well, if it's that easy, then pursue your case yourself. You clearly have the right answer. Google is the know-all, be-all. Obviously, I'm being facetious. The reality is, when it comes to complex injury cases, it's really complex. And the way I evaluate it, and the way that a good defense attorney is going to evaluate it, the way a good adjuster is going to evaluate it, is they're going to be thinking about, based on the facts of your case, based on the law of your case, what do they think that, and what do I think a jury would do after hearing the evidence? Now, that brings up a couple issues. Number one, you've got to remember about the rules of evidence. Now, what are the rules of evidence? Well, when you go to court, this is not a setting where, frankly, I tell people is really ripe for the truth. There's an artificial set of rules set by the legislature and by the Virginia Supreme Court that allow certain evidence to come in and certain evidence that can't come in. You have a very disjointed and short version about what's going on. When I'm representing you as my client, I'm usually going to know you for several months, several years sometimes, and we develop a relationship. I get to know you. A jury is not going to get to hear that. They're going to get to hear evidence that the court has found is admissible. And based upon that, and based upon other rules, they're going to have to make a decision. And oftentimes, the evidence that they get is not necessarily the best evidence. Now, I think we do a great job in presenting the best evidence possible for your case, but within the realm of those rules. So there are certain things that you may want to present that may absolutely be valid in your claim, but a jury may never hear. One of the big issues I often encounter is when I have a client, for instance, that's hit by a drunk driver, but the level of their blood alcohol level is not enough such that under the statute, it's going to be clearly admissible. Maybe there was other reasons that evidence of alcohol and their driving wasn't, quote, bad enough to where a court won't let me get that in. That's where I see a lot of issues come up. There are other issues, for instance, for small business owners like me, the law can be very difficult about getting lost wages in. If you haven't had a clear developed track history of income, if there's business that you don't yet have contracts for and things like that, it can be difficult for me to present to a jury evidence based on the rules of evidence, and a judge may keep that out. So you need to remember there are rules of evidence. So when you're talking to your attorney about the prospective value of your case, any good attorney is going to be talking about rules of evidence and what evidence may or may not come in. Other things like what may happen to you. Yes, you're fully recovered now, but you're concerned about what's going to happen to you in 2 to 3 years, and you've already went several months without treatment, and you're feeling good now, but you're concerned about the future. There's going to be certain rules of evidence about what a medical doctor could speculate or opine about your future care that's needed. The other thing that I also want to point out when it comes to what would a jury do is the inherent baggage that I believe that a lot of jurors come to court with when it comes to personal injury cases. If you're watching this because you were involved in a car accident and you were severely injured, and you never dealt with a car accident before, you've never had a friend or family member severely injured, you may have been under the impression, when you think about it, that you believe that all personal injury attorneys are ambulance chasers. There's too many lawsuits in America. There's too many frivolous lawsuits in America, and we need what they call tort reform, whatever that means. The reason that you may be thinking that, because you've never been in this world, is the insurance lobby has done a great job in educating the public wrongly, and convincing the public and marketing to the public that lawsuits are bad. And the reason they do this is really simple. They want to convince the public that insurance claims are all wrong, so they have to pay out less money. I'm sure you've probably heard of the infamous hot coffee McDonald's case. You may, if you've not been in this world before, and now you're coming to it, you may be under the impression that a lady was slightly burned by a McDonald's coffee because she was trying to drink it while driving, and somehow she managed to get millions of dollars. If you actually take time to research that case, what you'll learn tragically is a lady was severely burned in her genital area. I believe she was in her 70s. The coffee was so hot that it injured multiple other people, and the company had been warned multiple times that they need to cool down their coffee. And it wasn't until this severe injury that had to go to trial because McDonald's didn't want to pay her a fair share that ultimately the judgment was entered. I urge you to take some time to research that case and realize that that same baggage that you may have had before your own injury or your own family member's injury is going to be something that a lot of jurors are going to be coming to court with. Now, that being said, I don't want to give the impression that your case is worth nothing, particularly if you've got a complex injury and you have a very tragic story to tell. Our job as attorneys is to help educate the jury about the individual facts of your case, to help you tell your story credibly and compassionately, empathetically, and connect with the juries. We as attorneys, myself as an attorney, my job is to try to connect with juries. I like doing jury work. I like being in front of the court and arguing for people and helping them tell their story. But I just want to be clear that it's not as simple as some algorithm, because if it was, it'd be really that simple. We'd all see the objective numbers. The insurance companies would probably use that objective number and discount it and then give you a fair offer. And frankly, I wish they would do that, because then I wouldn't be needed. The litigation attorney would not be needed. Yes, I may have to find new work, but if that meant that individual injured victims of negligence didn't have to go through the stress that we end up having to go through and get somewhat fairly compensated, I would prefer that system, because that would mean that there'd be less pain and suffering, not only on the physical side, but on the emotional side, the financial side, the stress side, because litigation is not fun. And sometimes I will have clients that are frustrated when I can't give them a simple answer about what their case is worth besides what would a jury do. They want the answer quickly and upfront, but it just unfortunately doesn't work like that in most cases. In fact, we're just wrapping up a case now. I'm shooting this video in June of 2021. A lady was severely injured, multiple fractures to her hips and spinal fracture while she's walking through a crosswalk with a legal light. And we only settled the case weeks before the jury trial, simply because the insurance company would make no offers at all before. And they essentially required me to prove to them that I was willing to try the case. That's unfortunate, but that's just the way it is in the system that we have as it stands today. Again, hopefully it changes, but we are where we're at now. So hopefully this video answered the question often asked. But of course, if you have other questions, let me know. You can reach out to us at www.abreniolaw.com. You can give me a call, 703-570-4180. And look, I like shooting these videos. I think it's helpful for the public. So if you have any questions, make sure to reach out to me. You can reach me at james@abreniolaw.com. Maybe I'll shoot a video for you. Hopefully you found this useful. If you think it's useful to friends or family, make sure to share it with them. And also, if you want to subscribe to our YouTube channel, make sure to do that. We're trying to provide constant updates about Virginia law when it comes to personal injury, criminal defense. And sometimes we have some other issues on here as well. So thanks a lot. Hope it helped.